Good evening. Welcome to The Political View. There have been three separate commissions of inquiry running today. We'll go through each of them over the next few minutes. You'll have seen and heard the testimony from the Zondo Commission of Inquiry involving the former Chief Operating Officer of Bosasa. There is also, of course, the inquiry run by former Constitutional Court Judge Yvonne Mokgoro into the fitness for office of Deputy National Prosecuting Authority Head Advocate Nomgcobo Jiba and the head of the NPA's Special Commercial Crimes Unit, Advocate Lawrence Mrebi. Also starting today, the inquiry run by the former Supreme Court of Appeal Judge President Lex Mpati into the Public Investment Corporation. Let's discuss all of that now. Karyn Maughn joins us from Cape Town. She's a senior journalist at Tiso Blackstar, many years of legal reporting experience. Karyn, good evening, and thank you so much for joining us tonight on The Political View.
Well, thanks for having me.
Let's start with the Zondo Commission. That probably had more hits on the SABC's live feed than anything else today. The legal impact of this kind of evidence from Angelo Agrizi, it's given under oath, it's given on affidavit. Surely there must be legal consequences that flow from all of this.
Well, essentially, the NPA can use this, or the Hawks can use this as guidance for the kind of evidence that exists, and then access that evidence in terms of financial statements, etc. But they can't use the direct testimony of Mr. Agrizi as it currently stands. They will have to get him to make statements to them, and then call him as a witness. What is interesting, Stephen, is that there are going to be clear issues raised about someone who, on his own version, was significantly complicit with, alleged corruption, fraud, racketeering, money laundering, etc. What needs to happen, and what has been happening through this process, is that we see that Paul Pretorius, who is the evidence leader in this case, is painstakingly asking him questions about, for instance, the interior of Nomvula Mokonyane's home. Clearly verifiable evidence that can be traced back and looked at as a mechanism of verifying that he is in fact telling the truth. Of course, phone records, all that kind of thing, bank statements, these black books that keep coming up in the evidence as records of financial statements will all be crucial in terms of proving that Agrizi is in fact telling the truth.
I suppose if evidence like black books is submitted, it is at least kept safe. The Commission will look after it until the Hawks or whoever come and investigate it. There'll be a chain of evidence, if you like.
Well, this commission has shown itself to be very painfully aware of the importance of aspects of chain of evidence. Remember when they got those Gupta leak emails? They ensured that that drive was kept in a kind of very sealed evidential environment, and that access to it was limited. There was a painstaking process in bringing it back from Kenya into the country. And that was not an accident, Stephen. Remember that up until the time that the Commission accessed that hard drive, the Hawks did not have primary access to the emails. They were just acting off of media reports. So this inquiry, though it has no power to force the NPA to prosecute, though it has no power to criminally charge people, it is doing everything it can to lay a pathway for those kind of processes to happen.
Let's look at the Mokgoro inquiry now. So there are claims around Advocate Jiba, Advocate Mrebi. It might be important, perhaps, to just start with the actual terms of reference. This isn't a criminal proceeding like a court that we're used to, or even a disciplinary inquiry. We've seen those on live TV before. It's actually an inquiry into whether they are fit to hold their offices. What does that mean for how the Commission could make certain findings? Does it lower or change the sort of burden of proof in any way?
Well, what's fascinating, of course, is that this inquiry is being conducted under the NPA Act. So it's not a disciplinary or criminal process, as you rightly point out. We're not seeing a situation where, for instance, in the Tom Moyane inquiry that he faced, there are specific allegations against these two. It's really about, in the case of Advocate Jiba, for example, whether she exercised her powers to institute or review decisions to prosecute appropriately, where did she do her utmost to hold the NPA in good repute. It's the kind of broader issues of kind of the constitutional imperatives of leadership of the NPA that are being questioned here. Of course, the evidence leaders will bring in evidence. For instance, on the issue of whether Jiba exercised her powers appropriately, they will look at issues like her interventions in the Richard Mdluli matter, the withdrawal of those charges, what she did there. Was it based on proper information and proper prosecutorial discretion? Was her decision decision to pursue the racketeering case against Johan Boysen, the former KZN head of the Hawks, appropriately legally founded? Did she act in good faith? These are all of the issues that have been ventilated in multiple court processes. We know the GCB is currently appealing a decision by the Supreme Court of Appeal that overturned a ruling that both Mrebi and Jiba be struck from the role of advocates because they were not, fit to practice as advocates. We know the GCB is appealing this, but this is a very separate question. It's about what does the Constitution and the NPA Act demand of you as senior prosecutors within the Prosecuting Authority of South Africa, and have you done anything to undermine those constitutional and legal requirements?
The National Prosecuting Authority has had a very difficult history. I think the country's almost unanimous on that. There have been various cases, all of them involving politics in some way or another. There's the former head of the Police Intelligence Unit, Richard Mqluli. There was the Zuma spy tapes case. This was very much about the former president, Jacob Zuma, and the case that the DA wanted to bring around whether or not he should face corruption charges. So what then are the accusations against Jiba and Mrebi that come from their conduct in these cases? Where did these accusations come from?
Well, in the spy tapes matter, for example, there's a multiplicity of layers of accusation here that have sort of found their way into various court cases. But for instance, in the spy tapes matter, the DA launched that application to review the decision not to prosecute Zuma in 2009. But it took them, I think, in the region of 6 or 7 years to access the recordings that had led to the prosecution making that decision in the first place. And one of the key reasons for the delay was Jiba's conduct, that she refused to hand over, eventually the SCA giving a damning ruling against her in that regard. In the Mqluli matter, it was about the rationality of the decision to withdraw those charges. We know from, popular anecdote, evidence, the reports that Richard Mqluli was a self-proclaimed Jacob Zuma loyalist. In 2012, I believe he wrote a letter to the president basically promising his political loyalty as head of crime intelligence, that he would support his drive for leadership of the NPA, of the ANC. And we then see the NPA in the wake of this making these quite inexplicable decisions against the apparent advice of certain members of their prosecution team, including Glynis Breitenbach, to withdraw those charges. It's about the rationality of those decisions and whether, in fact, Stephen, they were influenced in any way by the politics. In the Johan Boysen matter, for which Jiba was actually charged for perjury briefly until those charges were withdrawn by Sean Abrams. She stands accused of essentially lying to the court and saying that she had evidence before her that would justify instituting racketeering charges, very serious charges under the Prevention of Organised Crime Act against Johan Boysen, when in fact, a judge of the High Court in Durban found that no such evidence existed and suggested that she'd essentially perjured herself. So those are the broad ambit of accusations. We know, of course, that this issue of alleged bribes from Bosasa has been raised by her counsel in today's hearing. But at this point, there's no certainty as to whether that will be brought into this inquiry. We know that the head of the evidence leader, Nazreen Bauer, has asked for it. But at this point, unclear whether those statements directly implicate Jiba, and if they do, what attitude this inquiry will take to that evidence. At the same time, Karyn, you'll know there's been Supreme Court of Appeal judgments that have criticised both Jiba and Mrebi. Would they be a part of this hearing? Do the views of judges in those cases actually matter, or do they pertain to this case? There will obviously be cognizance of this, but this is a separate inquiry. The evidence leader in this matter needs to get direct evidence from the horse's mouth about what the incidents that they believe may influence Judge Yvonne Mokgoro in making a decision about the fitness of both of these two people. So, it will obviously be in the back of the mind. We may see the evidence leaders bringing up some of those issues argument, but I very much doubt so, because they will want to say this is a fair process. We've asked the witnesses pertinent to these various issues to come forward. We know, for instance, that it's been reported reported that Jan Ferreira, who was a prosecutor involved in prosecuting Jiba for perjury, may be called as a witness tomorrow, and that he was very, very adamant in his opposition to the decision by Sean Abrams to withdraw those charges, that he believed that there was indeed a criminal basis to prosecute her. So this inquiry will have to bring those witnesses forward. A lot of, statements will be submitted. If there are substantive disputes of facts on those statements, we may see witnesses called. But I think the inquiry would want to present itself as having made up its own mind, having heard the evidence, having heard the testimony, and having come to its own conclusions.
So today, the start of the hearing, of course, it saw the current acting head of the NPA, Dr. Silas Ramayite, testifying. The new head only takes over, I think, in 2 weeks. What were the important parts of his evidence for you? What value did he bring to the Commission today?
Well, essentially, he was being brought in to discuss the kind of institution of the NPA itself. What is the NPA Act and the Constitution demand of a National Director of Public Prosecution? And this is particularly important in terms of these allegations about the withdrawal of charges, particularly against Mluli, being irrational and unlawful. Mrebi stands accused of, trying to mislead the court about the level of consultation he had with Advocate Mpati over that decision. So I think Silas Ramayite is not there to kind of take sides or to go after anyone in particular. He, as the NDPP, is just simply being asked to put it on the table as to what the requirements are in terms of these decision-making processes, how the structure of the NPA works in terms of doing that, and provide that as a backdrop to the subsequent evidence of what occurred, for instance, in the Boyson matter, in the Mluli matter, and particularly in the spy tapes matter about the withholding of those crucial recordings.
There does seem to be a little bit of a push from various parts of society to reform the National Prosecuting Authority. I think the President has pretty much said that that's what he wants to happen. There'll be the new head coming in soon, and Advocate Shamila Batohi. If you look at the entire institution, I mean, it seems that it won't just take one change of leadership at the top. It might take a whole change of leadership almost throughout the NPA. Is that what we're looking at here?
Well, I mean, we're hearing damaging evidence in the Agreezy testimony, which, of course, needs to be substantiated, that essentially the NPA or certain significant parts of it were actually captured by private interests, hell-bent on protecting themselves from feeling the full might of the law. And so those kind of issues of potential corruption within the ranks of the NPA need to be substantively addressed. The upper leadership of the NPA, I understand that Advocate Batohi may have expressed reservations about, the upper management and the kind of people that may or may not be there. She's made it very clear that she wants to, for instance, bring in a unit, Stephen, very similar to the disbanded Scorpions unit, where prosecutors are vested with investigatorial powers and can work with a number of people, including financial experts, the Auditor General, the FIC, etc., to build chunky, substantive cases that can make it through the hurly-burly of the court process and actually result in convictions. So it's that kind of thinking that I think needs to happen. I think there needs to be a substantive beefing up of the SIU's powers. We know that they've complained about the fact that they've done...
we do have to leave it there. Karyn, thank you very much indeed. Senior legal journalist at the Tiso Blackstar Group. Karyn, thank you so much.